So we have some sad news coming out of Washington, D.C. this week with the crash of that airliner and the Army helicopter. And, as pilots, anytime we hear about an airplane crash, it hits us pretty hard. And this is the first major airline crash since 2009. But every year there's a number of small airplane crashes, GA aircraft. Anytime that happens, we always talk about it. We look at it. We try to learn from it is the biggest thing. I think every pilot wants to learn from these things, but this one is particularly tragic. So I don't know what your thoughts were on that, Stuart. Or
Yeah, no, it's been a heavy week in aviation and air travel, especially in the United States, it's the safest mode of transportation there is, and the chance of somebody being in a midair collision like this is almost zero. But still, to these people that were in it affected them, and it'll affect their families forever after this. And it's sad. When you look at what was going on at Reagan National, the approach end of the runway there, and here to add complexity, there was a circle to land that was taking place due to the wind. So there's a direct runway there that hugs up onto the north side of the Potomac River, and so you have these VFR corridors that are running to the south side of the banks of the Potomac. I think I have my directions right here. I'm not familiar with that airspace, but these VFR corridors for the helicopters. And the important part here is that they have altitude restrictions. And if you look at the VFR corridor maps, they literally show 100 feet, 200 feet, 300 feet. So as the helicopters flying down the Potomac, they're able to raise the altitude they're flying at once they're past Reagan National, because what we have here is we have a VFR corridor that goes right through the flight path of the final approach for Reagan National. This is commercial airliners with the public at large flying commercial airliners into Reagan. And so
and it looked like the helicopters were supposed to be restricted to 200 feet at that particular area.
it looks like it, and there's some reports out saying, I know we follow some people on YouTube that say that they were more like at 300 feet, and that 100 feet does make a difference. The question I have is, why do you have commercial airliners and military aircraft flying this closely together this fast? It's very congested. And so right now they basically stopped the helicopter flying in that area. And do they continue it? I mean, they're going to have to figure out something, but you can't have helicopters passing in front of aircraft. And people are saying, well, how did was this intentional? Was it terrorism? How could you run right into an aircraft in front of you? And it's actually quite easy to run into an aircraft, especially at nighttime, if it's coming directly at you.
Yeah.
And especially if there's another airline that's off to the left, and you think that's the one that ATC wants you to look at, and you're not even seeing the one that's coming and hitting you, chances are the Black Hawk pilot never even saw this aircraft and hit it, and it was all over with.
Yeah, and Juan Brown on Blanco Lirio did a great job of talking about this air disaster. And it's interesting because typically when you're flying under instrument flight rules, which this commercial airliner would have been, you're supposed to be 1,000 feet from other traffic. But of course, on the approach end, you're coming down to land. There's less than 1,000 feet underneath you, and they're allowing these helicopters to go underneath at 200 feet. And so even if there is 100 foot of separation, that's not a whole lot of room. And we've both done a lot of hand flying, trying to keep. Well, you've done a lot more than I have, but trying to keep level at 100 feet. I mean, you can do it, but it takes a certain amount of concentration. And if you're distracted, it's not that difficult to go up or down 100 feet.
Well, that's the part here. They were distracted, it looks like, and then they're moving so quickly, you don't have time to fix it.
Yeah.
I will say the Black Hawk is a very advanced helicopter, and it could move very easily. So if the Black Hawk had even seen the plane at the last second, there's a chance that they could have evaded it. But I don't think they saw it, because they just fly straight into the jet.
Yeah.
And then it's over. But yeah, this idea that this VFR corridor for helicopters literally passes right in front of the landing traffic at Reagan National, it was just a matter of time until something happened.
Yeah. And it's very deceiving, because when another aircraft is at least during the day, if another aircraft is heading straight for you, it looks like it's not moving. It looks like it's just hanging there.
It gets bigger.
It gets slightly bigger, but it doesn't look like it's moving. It's deceiving, because when it's not moving, it doesn't feel dangerous. Versus a plane that's moving left to right or something,
Right.
You can see it. You feel so. It's very deceiving. It's not that easy to see other aircraft in the air, even though you would think that it wouldn't be that difficult.
Well, and then to make it even more problematic at nighttime,
Yeah.
you have no depth perception. Well, you have some depth perception, but your depth perception is taken away. And there's even a report out that the Black Hawk helicopters were using NVGs to fly. And these NVGs, the light distortion it's not perfect, and you
Yeah.
don't see things quite the same way. And so they were flying at night, no good depth perception, and NVGs, and they're looking at the wrong aircraft. Also, the FAA, we're finding out the FAA has 7 or 8 people working at the station when they used to have 15 or 20 people
Oh,
doing
wow.
the same job. And so you've got people that are overworked, tired. I mean, these are professionals, these air traffic controllers. Most of them are fantastic, and they're very caring. And it's a very stressful job. Many of them die early
Yeah.
deaths because they're just stressed out
Yeah.
trying to keep these things, keep these aircraft separated up in the air.
Yeah. Well, we'll see. We'll obviously be paying attention to the investigation reports, seeing what happens, but absolute tragedy.
Yeah,
And of course, our heart goes out to all of the people and families that are affected by this because it's just
absolutely.
terrible.
Yeah.
Yeah, it's just interesting to at least hear your guys' insights. And for the listeners, if they don't know, Stuart has a very interesting and admirable military background. Did you ever have spent time in those Black Hawk helicopters?
Oh yeah, I've repelled out of them. In fact, Fort Belvoir, which is just to the east of Reagan National, is where I did air assault school when I was in the Army. And we'd go in Black Hawks and we'd repel out of them. And I'll tell you that the fun thing about the Black Hawks is that there's 2 helicopters, and most people know the Huey. That's the
Yeah.
Vietnam era helicopter, and you see them on all kinds of movies. And most people understand that that's the helicopter that the Army uses. But the Army's been using Black Hawks for a long time as well. And the difference is when you repel off a Huey, the Huey actually it starts to go left and right depending on where the weight went out, because it's just not quite as powerful of an aircraft.
Yeah.
When the Black Hawk is there and you have 4 people going out, it just sits there. It doesn't,
It doesn't
move.
move.
No, it goes. I think it goes 200 miles an hour,
Which is impressive for a helicopter.
Yeah,
That's
I mean,
insane.
it's a really nice helicopter.
I mean, most helicopters go maybe 120, 150 miles an hour. So 200 is smoking fast for a
Yeah.
helicopter.
Yeah.
And we live in San Diego too. Obviously, a heavy naval presence. Is the Chinook? Is that another one? I feel like I
Chinook?
see that one
Yeah, that's
fly
a-
overhead sometimes too.
Yeah, it's got the 2 props you're talking about.
Yeah, it looks cool.
Yeah, I jumped off the back of out of the back of those when I was at the 82nd. It was awesome.
We see a lot of ospreys around here too.
Cool.
Yeah.
Well, great. Thank you for the insights on that, guys. We posted a question and hope listeners were enticed to give us some feedback, and we got a kind of topic of discussion. A listener wanted a deep dive on the legal pitfalls a new trustee can fall into in a trust administration and how to avoid them. I mean, I can understand this question because things and disasters happen, and hey, tomorrow I could be a trustee and I don't know anything about it. So I think that's kind of where this discussion stems.
Yeah, it's a good question. And it's, in terms of deep dive, I mean, we could probably spend hours literally talking about the pitfalls. But in terms of being able to answer the question, I've been saying we should do a episode of the podcast just on mediation. We should probably do one on this too. But the biggest number one problem that people have when they take over as trustees and they're not professionals or corporates is they don't study and learn what their duties are. And so they think, oh, I'm stepping into the shoes of my parents. I can do whatever they did. I'm in charge now. No, that's 100% false. The first rule is you have to follow the trust document. So what does the trust document say? Whatever it says, you have to follow it. There's all sorts of duties about investing, marshaling assets, treating beneficiaries fairly, even if they drive you crazy. Even if you think beneficiaries are annoying, you're the one who took on the job. Being trustee, you've got to do it. And if you don't like it, you can always resign and get somebody else in office. But I think the number one pitfall is not understanding your duties, the record keeping, the accounting, the transparency, the financial reporting, financial investing. I mean, and this is where hiring the right lawyer to advise you as trustee is so important, because that's the person who's going to hopefully give you guidance on all these duties and make sure you stay on the straight and narrow. But too often, people either don't hire lawyers because they think they know what they're doing, or they're, don't want to spend the money, which is a huge mistake, or they hire the wrong lawyer and the person just doesn't really give them good information.
Yeah, everything you said there is accurate. Although I think there is one thing that's even more important than you, and all the things you said are very important, but that number one thing is communication and transparency. And if a trustee would communicate, in fact, over communicate with the beneficiaries, letting them know what you're planning on doing, letting them know the timing giving them regular updates. Don't go crazy, but
Right.
give them regular updates. Here's one thing you could do. You could go to the trust bank account and you could ask that the bank sends out the statements to your beneficiaries every single month. Or once you get that bank statement, go ahead and you send it out to the beneficiary just without asking, just send it. When people ask for simple questions, give them answers. When they talk about everybody wants their money, when they ask about distribution, tell them, I want to make a distribution to you. There are certain things that I've been informed I have to do prior to doing that. Here's what I'm going to do. Here's my plan to get those done. Then when things invariably go wrong in your plan, let them know why. Oh, the CPA couldn't get to the tax returns like they thought. If you would just disclose stuff to people, it takes the temperature down. It makes them feel comfortable. And then in addition to everything else you said, as a trustee, you've got to invest the trust assets properly because you can be in a breach of the trust or surcharge for any of the losses there. You've got to treat the beneficiaries equally. Don't be paternalistic. The problem is most trustees come in and they're very paternalistic, and they usually have some vengeance against the trust beneficiaries that they want to take out for some, insult that happened 20 years ago.
Yeah. And you can actually look them up in the probate code, and you can look at all the duties. The duties are outlined right there, and it'll tell you exactly what your duties are. But I agree with you that if you did nothing else, if all you did was at least share copies of bank and brokerage account statements on a regular basis, that probably would go a huge way to taking the temperature down and making sure that you're out in front of the problem. And I think that's really what you're getting at, is just get out in front of the problem. Don't wait until it becomes a big issue.
Yeah. And if you got an appraisal for the trust property and you're the trustee, what should you do with that appraisal?
Share it, give it out.
Do you need to talk to your lawyer first about that?
No, just give it out.
Yeah.
Yeah. And the more you can give it out, the better. And that's the other thing that's great about that. And one of the kind of the harder parts of representing trustees, to be honest, is you always want to look reasonable. Even if you're not being entirely reasonable, you always want to at least give the appearance that you are. And by providing those copies once you get them, as soon as you get them, or within a reasonable time after getting them, it's a huge deal, and you can really avoid a lot of problems that way.
Yep.
That's a good segue into this next one. Someone wants to know, if a trustee is refusing to make a distribution, which petition should the beneficiary file? A petition for instructions or a petition for order of distribution, or neither?
How about both?
Yeah. I mean, you can, if you're bringing a petition under 17-200, you can kind of call it whatever you want. I would call it a petition for instructions, but it really is, it's both. It's also a petition for order of distribution, I suppose.
Well, it's a petition for instructions to order a distribution.
There you go. There you go. We got it. That's it. Write that down.
So people would go to 17-200 in the probate code. It's easy. Look it up. California probate code 17,200. You're going to see that this is the gateway to the probate court for trust litigation or trust administration issues, right?
Yeah.
And is there an exhaustive list of things that you can file there?
There sure is.
There is, and B1 through
B2,
B24 or something like that.
Yeah, there's like 24 different grounds to bring a petition.
Yeah, so the petition for instructions here would be petition for instructions to order a distribution. And so you introduce the parties, you explain what you're asking the court to do, you put some law in there, like maybe leaders versus court or something along that lines there, and then you nutshell it into a nice conclusion. And you file it, and the other side can oppose it. They can agree with it. They may not file anything, but that'll at least get you started on the process.
Yeah, get you down the road.
Here's one you guys might get a kick out of. How do you think a judge would react to a legal brief that analyzes all the documents in a motion package and presents an AI's unbiased opinion on the appropriate ruling? Helpful or offensive?
We should have a what do you call it? A section of our talk called "Helpful or Offensive."
Yeah, I like that. I like that. That's a great idea.
In this segment, is this helpful or offensive?
Yes, I love that.
If you have to ask if it's helpful or offensive, what is it likely to be?
It's offensive. Yeah, and I would, if I was a judge. Well, I don't know if I'd find it offensive. I'd find it amusing. I certainly wouldn't pay attention to it.
Yeah.
I guess my first thought too is, you're saying this is a AI's unbiased opinion.
Yeah.
How do you know it's unbiased?
Yeah.
I mean, AI is based on all the information out on the internet.
Right.
It's gleaning it from somewhere.
Right.
And all those sources that it's gleaning it from have some perspective.
But it's objectively using bias.
It doesn't matter if when you're a pilot, you always hear garbage in, garbage out.
Mm,
And so this is kind of the same thing. Like if you put garbage in the system, you get garbage
yeah,
out. So
yeah,
if you put biased into the system,
yeah,
you get biased out.
yeah.
So I don't buy the fact that it's an unbiased opinion. The other issue I would have with it is, at least under our system in California, I think it'd be reversible error if a judge comes out and says, "Oh, I let AI make the decision. I didn't make the decision."
Right.
Because no, the judge has to make the decision. You can't. It also would be reversible error if a judge said, "Oh, I flipped a coin
Yeah.
and it came up heads, and so that's how I ruled." That
Yeah.
also would be reversible error.
Right, right. Well, yeah, and my response to this, Keith, is that we as lawyers, when we're litigating something, want to be persuasive in our writing. And so we don't want an objective view
No.
of it. We want to persuade a judge that we're accurate. Now, you want your persuasion to look like it's being objective. You want
Right.
your persuasion to look like you're following the law. But being a lawyer is, there's a lot of gray areas out there, and there's a lot of discretion that trial courts have. So I don't want to walk in and say, Your Honor, I'm being completely objective here. Your Honor, I'm looking at this like what's good for both parties. No, the reality is I'm only looking at this for what's the best I can get for my client, and how can I do that from a rhetorical standpoint where it looks palatable and the judge likes it. That's really what we're trying to do.
Well, and if you're giving the judge, here's something AI did that was objective, what you're telling the judge is, I don't think you can be objective.
Yeah.
And so here's what AI said. I mean,
Yeah.
I think that's where it gets a little offensive towards the judge.
Yeah, yeah. Whoever sent that in I don't mean to laugh at it if they really think it was a good idea. I don't want to hurt anybody's feelings, but yeah, you want to be careful. I know with judges even, and by the way, and I'm not just saying this, I think judges work their tails off in California. They're overworked. They have too many cases. They're doing the best they can. When I find that a judge maybe didn't have a chance to fully read what I gave them, or maybe I didn't do a very good job explaining it, that's usually what I'll start with. I'm like, Your Honor, I probably didn't do a very good job explaining this, but can I take one more stab at it? And you explain it, and then hopefully they'll see the argument falls in line with what they reviewed.
The other thing that you said, though, is that how we are advocates, we don't want to be objective, but you want to appear that way. And, I can draft a fact section for a brief, and I can make it appear as though these are objective facts, but they're not, because I'm deciding what facts to put in there and what facts not to put in there. And I'm deciding the order in which I'm putting the facts. And so you can be pretty persuasive with a sequence of facts, even. I haven't even got to the argument yet, just the fact statement. You can be pretty persuasive with it if you understand what you're doing and how to build it.
Yeah. We know two appellate attorneys, Jeff Ehrlich and Alexandra Ward, and we're both impressed with both of them because they, in their facts section, well, they do their whole brief correctly, but in their facts section, you're not supposed to argue when you go up on appeal. You're supposed to just state the facts as they are, right? But
Right.
yet they state the facts so beautifully that it just leads to the result that leans in their
Yes.
direction.
Exactly.
And we both have been highly impressed. But that's a skill set. That's something that somebody's worked on and honed for years.
It's amazing, but
Yeah.
it's not objective.
Yeah, no, it's not. No, but yet if you were to argue openly in the fact section, you'll get called out by the appellate court if you do that. So,
Oh yeah, no, not only you're not supposed to do it, but it's a complete turnoff.
Yes.
And yet, if you lay out the facts and they look objectively reasonable, but
Right.
you're choosing the right facts,
Right.
you're choosing the right order.
yeah. And by the way, I found some of the best closing arguments that I've ever seen are somebody that's just nonchalantly stating, these are the facts. You guys know, you were here, you saw that. Here are the facts, and here's
Right.
how they go. And yet, this is an argument portion of the case. In fact, what a lawyer does in closing is not to be accepted as evidence. What they say is not to be accepted as evidence. But you, as a lawyer, just being there and saying, hey, everybody knows this. You guys were here. You saw the people that testified. You know these are the facts. Those are very compelling closings.
Yeah, absolutely. And I guess I have a problem too with the whole unbiased idea. And I don't mean to take this down yet another road, but Daniel Kahneman's very famous psychologist.
Thinking Fast and Slow.
He wrote Thinking Fast and Slow. And in that book, they talk about this study where they have people who had brain damage, and it was damage to their brain where they couldn't feel emotions. And so they took these people and they gave them a series of decisions because they're thinking these are people who are going to make purely rational decisions.
Like Spock on Star Trek.
Right. And so they gave them a series of, problems where they had to make a decision. And so did they make a rational decision or did they make an irrational decision?
I'm assuming very irrational.
They made no decision at all.
Oh, okay.
They were incapable of deciding. And so obviously the conclusion is you have to have some emotion to get your brain and your, I guess, whatever decision making to actually latch on to one of the decisions. And so I think that's true, obviously, of people. It's true of judges. It's true of juries. And so why does a judge make a certain decision? Well, it's not entirely unbiased, is it? Now, it's unbiased in the sense that they're not involved in the case and they don't, represent either side. But it's not truly unbiased in the sense that they bring their own experience and life experience. And we've seen that in our cases where a judge is like, well, we had a judge tell us once, well, when my mom died, my sister lived in the house for 10 months and that was okay. So why should I kick this person out when it's only been 9 months?
Right.
Okay. Well, that's not entirely unbiased, is it?
Right. Well, and not to go down another path, but I want to. We both have read a book called Reptile by John Keenan and David Ball. And Reptile is a great book. In fact, there's jury instructions now that the defense lawyers routinely file saying you can't make the quote unquote reptile arguments to a jury because they're so compelling. And so what are reptile arguments? Well, the whole thesis of Reptile is that there's a reptile brain, and then overlaying that reptile brain is an emotional brain.
Yeah.
And then overlaying that emotional brain is the most recent part of our brain that's grown, and that's logic. And so try this. Next time you're in a fight with your significant other, okay?
Well, this is good advice.
Okay.
Write this down, Eric.
Are you based on emotion that is good for both of you? And don't argue on logic, because all logic does is discount the emotional response that somebody's having. And so we see this happening all the time. When we go and ask a jury for millions of dollars for a wrongful death case, we're appealing to their emotions. We're appealing to their emotional brain. The defense attorney is going to start arguing a bunch of logical reasons why you wouldn't give this $1 million. And they lose 99% of the time. And the reason for that is our emotional brain has been around for so much longer than our logical brain, and our emotions trump our logic. And so don't use logic to beat somebody up when they're having an emotional response to something. Use emotion, not attack, but try to attach emotional communications with somebody
and understand that.
And don't just tell them, well, I'll give you a good example. If your mom died tomorrow and you're crying, and I come to you and I say, well, like a year from now, you're going to be fine. So why aren't you just fine now?
Right.
Because you haven't worked through the emotional response and shock to learning that your mom passed away.
Right.
And are you thinking about anything else after your mom? You're not thinking about what grocery list is. You're not thinking about all the errands you need to run or all the stuff you have to do. You just found out your mom died. It's horrific, right?
Yeah.
This is a bad example. But the point being, that emotional response you're having there, I could never logic you out of it.
Right.
But I could tell you, oh my God, I'm so sorry. I lost my mom last year, and I know how painful it is. And, I want you to know you'll get through this, but right now it's going to be tough. Boy, that's a different response than, why don't you just get over it, because you know you're going to get over it in a year from now.
Yeah, exactly. And I think Reptile meets the thinking fast and slow so nicely, in the sense that, yes, there's emotional based decisions, and they have to be. And I always think about it as, you see a fancy sports car and you buy it because you fall in love with it. And then afterwards, somebody asks you, why did you buy that car? Well, it has really good safety record, and it's got particularly good resale value.
And I got a good deal on it.
Yeah, no, you're backing into the logic of it.
Yeah.
That's really, because nobody wants to admit, oh, I fell in love and I couldn't control myself.
Yeah.
Nobody wants to come out and say that, but that's what's really going on, I think.
Let me say one final thing. Last path.
Please.
Sorry, Eric. Producer Eric's looking at me. He's pulling his knife out over there. What does that mean?
Move on.
Judges. I think judges are good people and they want to make good decisions. Yes. They're busy. They're overwhelmed with all the cases they have, but they want to make good decisions. I think judges make an emotional decision on a case, and then they back themselves into the law. Now, they'll never admit that, and they shouldn't admit that. It should be a cold analysis where you have a judge looking at the black letter law and the facts and make a determination. But judges are people too, and they want to make decisions they can sleep with, that they can go to bed with knowing they made the right decision. And so if you're making an argument that is very unfair and it's going to harm a lot of people, and you're the only one that's going to win, chances are that argument's not going to go over well with the judge.
Yeah, you have to think about that. What makes the judge feel good?
Yep. Sorry, producer Eric. Man,
don't apologize to me.
There was eloquence. I mean, Keith and I just wanted to share.
I think we would call it a blizzard of brilliance.
Well, hey, not to rehash anything, but this is from the same listener, and they preface this saying that they were watching an ABA webinar, American Bar Association, and they were saying a judge claimed he can upload every file in a case and have AI write a 55-page opinion. Refuses to specify which tool he uses based on context. I suspect legal fly. Do you have any insights or experience with this or other AI legal tools? I don't know if you guys have to play this close to the vest or anything or not, but
Well,
this person was curious.
we have experience with AI tools, and Stuart loves, he's got that all figured out. So I'll let you talk about that. But as
Thank
far
you.
as, yeah, you're welcome.
Appreciate that.
I'll
That was
allow,
very kind of you. Wow.
I'll allow it.
I'm allowed.
I'll
Eric.
allow-
All right, go ahead, Keith. All right.
Sometimes I don't phrase things properly for the reptile brain.
I will allow you to continue.
Thank
sir.
you. Permission
Oh,
granted.
I'm sorry. Did I interrupt you?
Once again, you did. Now I lost my train of
We're
thought.
talking about AI.
Oh, yeah. I think it'd be a reversible error if you found out a judge used AI to make a decision under our law. And I know I probably said that before, but to think that a judge would put everything in AI and come up with a decision, I think that'd be a problem. And, I don't think the judge should be like admitting that if they are doing it. But I'm sure that there are AI tools that they're using and can use.
Well, I think you hit it on the head. AI is a tool, and we should use it, and we should look at it. And I think that schools, like high schools and colleges, have struggled with this because what is plagiarism and what is using AI to enhance your ability to write a paper? If you enhance your ability to write a paper, I think it's fantastic. If you take it word for word, it's a problem. Same thing with a judge. So I have no problem if a judge wants to dump everything into an AI file of some kind, doesn't matter which tool it is. There's all different sorts of tools, legal tools we use out there, and wants to see what AI says about it. We're smart people. Once we're in the ballpark and we see these things, and based upon our experience in this area, we can enhance what we see from AI. So AI is just simply a tool that we use. Think about this. Before AI, a judge would have asked a clerk to pull together some research so that the judge could look at it to judge that research, to see if that's where they want to go with the decision, right?
Mhm.
Now you're having AI also provide you with some insight. And again, as long as you're not relying on it line for line, word for word, I think it's a fantastic tool.
Yeah. Yeah. That makes sense.
Okay, let's get to this one. This is a first time person. I could tell when they texted the hotline, first time, long time sort of thing. So they said if a settlor had mental capacity per medical records at the time of trust amendment, does that mean there couldn't have been undue influence even if he or she was physically ill? And would this situation be a bad candidate for an undue influence case?
So go back to the first part of that. So if a settlor had mental capacity per medical records,
But was physically ill, which
it doesn't. No, I mean, having medical or mental capacity doesn't mean that it's not undue influence. You can still have mental capacity and have undue influence. And the code cites all sorts of different ways in which people can be vulnerable to undue influence. It could be age, it could be illness. It could be that, your spouse just died and you're dependent on somebody. There's all sorts of different criteria. Now, the best cases tend to be where somebody does have a mental defect, dementia, Alzheimer's, stroke. Those are the cases that kind of get the best attention, I think. But it doesn't have to be that way. The code specifies all sorts of different ways that an elder can be vulnerable.
Yeah, no, a very bad example here would be Adam and Eve. We all know about Adam and Eve. And if Adam and Eve were both in their 30s, let's
Yeah.
assume they were in the prime of life when they met. And Eve said, "Hey, I ate this apple. Would you like some?" And he said, "Yes." And he knew exactly what he was doing. She didn't unduly influence him to eat the apple and join her in the world of sin, according to the Bible. But let's change the facts of Adam and Eve as we understand it. And Eve is 35 in the prime of life, and Adam is 82 and in a hospital bed and has a breathing tube. And Eve comes to him and coaxes him to eat the apple. Is there undue influence in that case? And there may be. And so even though he might still have some capacity at 82 in a hospital bed, the chances of him being influenced to do something beyond what he would do, but for that undue influence, that is likely to happen in that kind of a case. So if we just pull it into let's take it away from the Bible, because you're looking at me like, why did you bring the Bible into this? And
I'm
if we
fine,
just
Bible, no Bible.
and if we just talk about what cases we do see, and that is generally if somebody makes a change and they're fine, and 5 or 6 or 7 or 8 years go by, and then they get dementia and Alzheimer's, that change is good. It's going to be hard to undo that change. You're going to have to really come up with some evidence that shows that wasn't what they intended, versus a year or 2 or 3 before they die and they're suffering with Parkinson's or dementia or Alzheimer's of some type or some mental cognitive deficit. They're still capacitated Yes, the exercise of undue influence can definitely take place, and it would be easier to prove in that case than it would the first.
Yeah, it's just easier to prove. I was just thinking about one of the other elements that the code specifies that could show vulnerability of the victim is education level. And that kind of makes sense. I mean, if you have somebody who just doesn't understand that much, but they, were left a large estate, and then somebody comes in and is like trying to confuse them and make things overly complicated. But again, I don't think that even though that is in the code, it's going to be a harder case.
Yeah. Yep.
All right. Thank you, guys.
You didn't think I'd go to Adam and Eve, did you?
I never know.
You
I
never
You
know.
never know.
We're good with anything on this show, though. Okay. Does the trustee hiring an attorney, and I have a feeling there's no magic one answer to this. There can be a amount of pathways, but does the trustee hiring an attorney indicate a positive development, meaning the attorney will guide the trustee to follow the trust terms and make an outright distribution to the beneficiaries?
Yeah, I mean, I think so. I think more often than not, if a trustee hires a good trust attorney, it's a good development. And, of all of our cases that we handle on the litigation side, we prefer the cases where the other side has hired competent attorneys.
Competent attorneys being the key terms.
Yeah, competent attorneys who knows what they're doing in this area. Those are the cases that we feel the best about. When they hire attorneys that are not competent or have no clue what they're doing in this area, it's going to be a long slog. Oh, such a nightmare for everybody. And they don't do their clients any service, that's for sure. But I think if a trustee goes out and hires the right attorney, that's a good sign.
Yeah. Yeah. I think, again, competent attorneys matter.
Yeah.
If you hire somebody that doesn't know what they're doing, it's going to stretch the case out.
I would be careful, though, because people say, well, they hire an attorney who's going to make the trustee do the right thing. No attorney can make a client do anything. We know that all too well. So, but they can certainly advise the trustee, and hopefully the trustee listens.
And if a lawyer really felt that there was an ethical issue, they could withdraw from representing that trustee going forward.
Right.
It doesn't happen often, but every once in a while it does.
Yeah. All right.
That's a good segue into this next one here too. When a trustee has an attorney and a beneficiary wishes to request the trust accounting and financial records, should the beneficiary send the request to the trustee or the trustee's attorney? And maybe it's not a big deal here, but to a non-lawyer like myself, it's like, hey, is this a order of operations that can't be done or undone? What's the answer here?
Well, if you sent it to the attorney and the attorney truly does represent the trustee, you have communicated with the trustee because the attorney is the trustee's agent. But I always feel like these notice issues, I feel like you should send it to everybody. So if you have emails for the trustee and their lawyer, that's what I would do. You agree or disagree?
Yeah, I would send it to both. Just send it to both of them. But I mean, I guess when in doubt, as long as you know the attorney truly represents the trustee, you can just send it to the attorney, I suppose. But why not both?
You know what this reminds me of? When I was a younger attorney, I used to send everything by certified mail. And then I learned you not only have to send it certified, you have to send it regular as well.
Because they'll refuse it.
Because they'll refuse the certified package. So that's how I did it. So it just reminds me of just send stuff as much as possible to everybody.
Yeah, email it.
Smoke signal it.
Yes.
Pigeon, carrier pigeon.
Carrier pigeon. Yeah, right. Exactly.
I mean, like we said, just over communication, kind of the theme.
Yeah, that's right.
Alrighty. Well, yeah, that's all we had for the questions that were, gathered. What's anything next on your guys' calendar? Any upcoming trips?
Oh man, I'll tell you, January has been so busy, and I think February is shaping up to be just as busy. We have a slew of mediations coming up.
Yeah.
We're going to be flying all over for those.
Yep.
Yeah, I can't even think of all the things that we're doing, but we're doing our best to keep the lives going on Fridays. We really enjoy doing this, and it seems like we're getting a lot of really great questions.
Yeah. Yeah. We're always happy to answer questions or at least get people in the ballpark, and then they can reach out to their own lawyers or find lawyers. One of the keys that I always want to say is we're not giving legal advice to anybody in any of these lives. We're just doing our best to point you in the right direction. But if you're doing a trust and estate litigated case in California, Keith, a Google search for trust and estate litigation lawyers is going to give you a plethora. Isn't that for the three amigos?
Yeah, plethora.
What is a plethora? It's going to give you a plethora of law firms that more than likely specialize in this case. And then, my recommendation is to call lawyers and treat it kind of like a first date. And do you have chemistry with the lawyer? Does the lawyer have chemistry with you? If you find a sense of good relationship, that's a lawyer that more than likely is going to like you, like your case, and want to do good work for you. and head down the road there. But the worst thing to do in my mind is to ask a friend, hey, do you know any lawyers?
Right.
And you go see some, and I don't have anything against personal injury lawyers, but you go to some personal injury lawyer who maybe is a little slow, and all of a sudden they decide they want to cut their teeth on a trust and estate case. These are very complex cases.
Yes.
And, there are firms out there that are very good at this. And then there are other firms that are not so good at this. And so you don't want to get caught with one of those firms that doesn't know what they're doing.
No, and it makes a huge difference, the attorney you have to your case. I mean, it has to be the right attorney for your case, and you have to feel comfortable with that person. But yeah, no, I agree completely. Yeah.
And I'll be honest. I mean, we only take a few select cases. We don't take that many cases on. But if somebody wanted to reach out to producer Eric or reach out to us for referrals, we'd be happy to give people 2 or 3 names so that we're not limiting it to one person.
Yeah.
And that way you could call those individuals and see if they could help you out.
Yeah, there's not that many people in the state of California that focus solely on trust litigation. So all of the firms know each other.
We do.
It's a pretty small group of people. But yeah, we're always happy if it's not a case that's a right fit for us. We're always happy to give referrals.
Yep.
So I feel like you said some really good things today, Stuart. I'm really happy I let you speak.
Oh, well, thank you.
Yeah,
that
was a good decision on my part.
I haven't spoken all week, but now that you've taken the muzzle off,
I feel like that was a good decision for me to make.
I remember one time I was in a mediation, and it was when I was a younger lawyer, and there was a female attorney and a female mediator. And I said, well, Your Honor, I'm gonna make this presentation, and then I'll let so-and-so. And I remember the judge looked at me and she goes, "Oh, you're going to let her, are you?" And I was like,
that doesn't sound good.
Yeah, it really hurt. So I've wiped that from my vocabulary. At least I've tried to.
Yeah, I guess I got to work on that.
Well, you're kind of a controlling person, though.
Oh no, nobody says.
I mean, you're more controlling than I am, isn't it?
Don't talk.
Pretty
right
sure, Eric,
isn't
that true? That Keith's more controlling.
No comment. No comment.
Eric's like, I got to live the next week.
Yeah. Well, cool. Any other cleanup? You guys mentioned anything on the last show that kept you up and you're like, oh, I made a mistake?
Oh, Eric, I don't sleep because of things I say, but it might be more than just the show from last week. But
yeah. All right, cool. Well, that's it. Well, great show, guys. Thank you for your time.
All right. So every Friday, we're still trying through the month of February, every Friday at 1 p.m. Pacific.
Yep.
And we're live. You can text us, right, Eric? You can text us. You can call us.
Leave a voicemail if you want.
You can join the live. And we will try to get to all questions.
Absolutely. Yeah, we're here for the listeners. And we're still waiting on a name. I don't know what to, if people have a name for yourselves,
Oh, you want to name the listeners?
Yeah, I said Askies last time. You guys laughed me out of the building.
What's the segment that we want again?
Helpful or offensive?
Yeah, helpful or
that.
offensive. I like that. It's a good segment.
I'll have to add that
in the helpful and what is it? Helpful and what?
Helpful or offensive?
Helpful or offensive segment tonight. We have 2 fact scenarios.
H or O.
Yeah.
Yeah.
Oh, there is one question that just came in.
Oh, here we go. Let's get to this. Yeah. Undue influence case and flipping the burden of proof.
Yeah, I flip it all the time. So.
Well,
how do you flip it?
She's
Keith?
not talking about that. You're not flipping the bird. You're flipping the burden of proof.
Oh, okay. All right.
That's the difference.
All right.
Yeah, it is interesting in undue influence cases where there's 3 factors where you can flip the burden to the other party, and they have to prove there wasn't undue influence. And so if you prove the 3 factors, then you're good to go. So you have to prove that there was a confidential relationship. You have to prove that the person actively engaged in procuring the document. So they took some action to make it come about, and then there has to be an undue benefit. And I think a lot of cases people think, oh, we're going to flip the burden. It's actually kind of confusing when you go to trial on that, because most judges aren't very clear about. You would think that you would first determine whether or not the burden has been flipped and then go from there. But that's not how most judges do it. They're just like, well, present your case, and then at the very end, I'll decide whether or not this happened or not. So it's a little bit of a confusing concept when you're actually in trial. But that's the concept of it.
Yeah. So keep in mind that if you file a trust contest, you generally have the burden of proof to the trier of fact.
Yeah,
here's
right.
Probate judge to prove the case. And that's using evidentiary standards, which is preponderance of the evidence in most cases, but it can also be clear and convincing evidence in certain others. We don't have the criminal standard beyond a reasonable doubt. That's for criminals. But we do have clear and convincing evidence, which is higher than preponderance. And then you have preponderance of the evidence. And you generally have that burden of proof. But you can shift that burden to the party that you're going after, saying they committed or they were involved in the exercise of undue influence over an elder or financial elder abuse or whatever the case may be. And what you do then is they have to say that they didn't. They have to prove that they did not, which we call it proving a negative. It can actually be pretty problematic to do.
It's almost impossible.
Right.
But flipping the burden is not as easy as it sounds, because the procurement element is a little tricky, and the undue benefit element's a little tricky, because it's not the fact that they end up with more is not in and of itself undue benefit.
Right.
You have to determine whether or not that's something that the settlor would have intended.
Right.
And so it sounds straightforward, but it's not as straightforward as it sounds. But it's still a useful tool, and it's one that you would want to include in most undue influence cases where you have the necessary elements to do it.
Yeah. If you have a confidential relationship, I think that usually at the beginning of a case, at least, gives you enough to say, hey, I think we're going to be able to shift the burden in this case. And then, of course, you go into discovery and depositions, trying to prove up all three of those elements, so that you can shift the burden at the time of trial. And I've experienced the same thing you have, Keith, and that is a judge, you show up thinking we're going to have a mini trial on whether the burden should shift to the other side. And most judges just say, put on your case, and then I'll determine at the end if the burden shift applies.
Yeah, it just turns into a big mess, and then the judge figures it out on the back end.
Which, again, goes back to something we talked about earlier. Judges make decisions they like. So if the burden is shifted, chances are they really don't like the person that they're shifting the burden to.
Right.
If they say, no, we're not going to shift the burden, it's because they don't feel good about that decision.
Which is one of the reasons you bring that claim. It gives yet another basis that the judge can latch on to if they want to go your way.
That's right.
Reptile brain, emotional brain, it all comes full circle.
Yeah.
All right. Next week,
guys.
Eric?
Yeah, we'll see everyone next week.
All right.
All right. Take
Have
care.
a great one.